Hello and welcome. My name is Kubeir. I am a CICC licensed immigration consultant, and this channel is all about Canadian immigration news, updates, things you should do, things you definitely should not with your Canadian immigration application. And just as what we try and do to bring you tips and updates and little things that you are aware of, little things you are not aware of, things you should be looking out for, and also looking at answering lots of questions, lots of queries that you have, concerns that you have. One of the biggest ones, of course, who wants to see it? Who wants it? An application refusal. No, that's not how you prepare an application. You are preparing your application because you want it to get approved. But an application has a mind of its own. IRCC has a bigger mind of its own. Mistakes do happen, sometimes knowingly, sometimes unknowingly. And when that happens, then the result is not what you were looking out for, not what you desired. So today I have with me as my guest, Lev, who is an Canadian immigration lawyer. And I'm going to have a discussion with him as to what are your options, what are the remedies that you can look at, what can you do in case you get an application refused. So let me welcome Lev Abramovich. How are you, Lev?
I'm good. How are you, Kubeir?
Excellent. Thank you for joining me again this time. Last time you were here, we were talking about the mandamus applications. And before we jump in to the refusals and the rejections and what are the options that we have, let's very quickly touch base with mandamus. Is that still the hot topic?
Yes, unfortunately, it is still a hot topic. So since we last spoke, I think we're on about 450 applications now. Wow. So we've been still doing a lot of them, still good results. We're hoping to see the backlog and sort of the operational side of things improve. And we're hoping that mandamuses will stop being as important as they currently are. But we're still assisting clients on both the citizenship, TR, and PR side of things. In general, I think the government is taking the backlog seriously, and I think they're going to do some drastic sort of things to try to reduce it and hopefully try to eliminate it. And my hope is that going forward, we won't just have a backlog, but we'll have a functional system that is fair, that is transparent, and where applicants know when they're going to expect the decision and decisions are made in a procedurally fair manner.
That would be in 22nd century, or we're looking sometime this year, next year?
I'm hoping, you know what, there's been a lot of pressure from immigration consultants, from lawyers, from applicants. There's been a lot of media coverage. And I'm hoping that the government will finally start doing more than just looking at, the backlog and are just trying to sort of do things that are politically maybe positive. But I'm hoping that they're going to take a hard look at the actual system and start changing it for the better.
Yep. I did see a recent memo on the Globe and Mail, which indicated that they have their hands on a memo which says that IRCC is looking to make some very aggressive steps, or rather take some aggressive steps with regards to TRV applications. And they're looking to probably either remove the eligibility requirement, the section 179 subsection B, whereby the requirement for an applicant to prove that they will indeed return back to their home country, that is removed for 495,000 applications. That basically would mean everybody gets approved, right?
Yeah, well, we still don't know the details. First of all, great job by Matt Lundy at the Globe and Mail. He does fantastic work. I've had the pleasure of talking to him about a couple of articles. So great job by him. Ultimately, we should be asking, why is this stuff coming out by way of an investigative piece by the Globe and Mail, as opposed to by way of perhaps consultations with stakeholders, and maybe just more transparency with respect to the things that IRCC is looking at. So yes, you're right. I think they're looking at basically trying to eliminate the backlog or trying to seriously reduce it on the TR side of things by waiving eligibility and essentially creating a mass sort of visa amnesty, if you will. I think that the chances of that are quite high, just because the system is basically a mess and there's nothing else that I think they're able to do to clear it. So there are a few interesting questions. Eligibility doesn't mean approval, because there's still security, criminality, etc.
Of course.
Next, if they're going to create a system whereby all of a sudden, a couple of 100,000 people are approved, what does that say about, those who are not coming here as genuine visitors? So we're potentially going to see either migrant workers or people who are coming here not to visit but to do something else. Some of them will, of course, be seeking refugee protection, which is perfectly fine, because this is not an unreasonable thing to do if you're facing persecution. But I think there'll probably be a swamp of other issues that will come out of this bulk approval that is then going to possibly create other issues in the system. And what I'd like to do is not just see a mass approval or approval in bulk, but I'd like to see some addressing of the underlying issues. To me, and this may be a gross example, if somebody has gained a lot of weight through an unhealthy lifestyle, this is not sort of a critique, and then somebody undergoes a medical procedure, that medical procedure can potentially be a short-term solution. We need to be looking at lifestyle factors, et cetera, et cetera. So how did we get here? Why are we doing this now and not 6 months ago or 8 months ago, or maybe when the backlog started? And what are the underlying issues? In my mind, we have to look at the consulate system. Why is it so prevalent in our sort of processing, on the processing side of things? Why can't we have more processing in Canada? Why don't we have an agile and centralized system that basically looks at applications at first in, first out, uses AI to pre-screen and possibly appraise applicants of issues? Why is the GCMS system still being used when it's old and outdated? Why are profiles and portals not linked to an electronic management system? And many things like that, basically. I hope that they're not just going to do this visa amnesty, but they're going to sort of rebuild the system, as I say.
$85 million that was spent during the last year, $750 million again allocated in the budget to for the technological advancements. Let's see where that money is spent. But what you said, I agree with that. Mess. Sometimes I think mess is an understatement of what's happening at IRCC offices across the world. I mean, yes, some visa offices do a better job than the others, but
why should it depend on the visa office? If you file a mortgage application, right? Is this going to depend on what visa office? There should be a clear set of criteria. And as with all online applications, why the backlog in the first place? This is not a microchip issue. It's not like they're waiting for lumber from China to come in so they can work on the application, build something. It's an online application. So, and a lot of this is blamed on COVID.
I agree with you on that. But I think there was a deeper issue that ran between the IRCC offices with the COVID hitting. That is, a lot of visa officers came back. A lot of local hires which were assisting the visa officers, they were let go. And when after the COVID, they all went back, or some of them went back. I understand some visa offices are still not, with the staffing levels, they're not up to date, or they do not have the complete staffing levels. They still haven't rehired a lot of people. It went into a total mess, and obviously nobody was looking at the applications that were gathering dust, and so on and so forth. But I guess that's what I said. Mess is an understatement, and IRCC is just, a first world country should have got this sorted out. But anyways, so that is a discussion for another day as to what's happening with their backlogs and what they're doing with it. But today's topic, which is so much more prevalent in what's happening, and of course it will also be prevalent with all these backlogs. There was a time when we started hearing from a lot of Indian students, a lot of Asian students, that the rejection rate or the refusal rate for study permit applications has gone up drastically. Obviously, a lot of agents out in India made it out to be that because there is such a big backlog, IRCC is cancelling applications or refusing applications in bulk. That was the first one. Second, we heard was the use of artificial intelligence. I'm sure you're already aware about Chinook, and as to that they are using the tool, which I don't agree with because I've seen a lot of that, to refuse the application. I don't think the tool is to refuse the application. The tool is to better manage the processing of the applications. But that is what the agents made it out to be, creating this panic amongst students and other applicants that their applications will be refused because that's what IRCC does. So today's discussion is about what does a person do? What are the remedies available to a person? Study permit, visit visa, work permit, PR applications, agencies, refugees. So if you could just quickly break down in some pointers, and then we go into details as to what the person can do, from temporary residence applications to permanent residence applications. You get a letter email, your application is rejected or refused. What do you do?
Okay, so firstly, I did prepare a presentation on this. Do you want me to dive into the presentation or just to talk broadly?
If you can give me pointers first, and then we can go into your presentation as well.
Okay, so pointers. First thing that I would generally recommend is, because when we're talking about judicial reviews and we're talking specifically about visa denials, consultants do not have the right to appear at the federal court. So first and foremost, I would probably recommend that you speak to an immigration lawyer who specializes in immigration litigation. So understand what your options are. Generally speaking, your options are file a new application, ask for reconsideration, and possibly with the reconsideration as well, file a judicial review just to either protect your procedural rights to a judicial review. If you submit an application from outside of Canada, you will generally have 60 days to commence a judicial review. Once you commence the judicial review, typically, if you haven't received reasons, you'll receive reasons. You can go over those steps. You can get to the next steps.
Okay.
And once you get those reasons, it makes sense for you to then determine what is the best course of action. For example, if you think the reasons are materially deficient, you may proceed with the judicial review with the hope of a relatively quick settlement with the Department of Justice. So let's say within 40 to 60 days, you settle the matter, it goes back to a different officer, and hopefully you get an approval. If you think the matter cannot be settled quickly, it may make sense to address some of the issues by way of a new application and then file a judicial review just out of an abundance of caution, so that if your new application is not approved, you can proceed with the judicial review and overturn the decision and ultimately, hopefully, get a positive decision. Reconsideration requests are sort of interesting in the sense that there's no statutory right to reconsideration, and an officer may choose to reopen the file or may not choose to reopen the file, and then you can actually seek a judicial review with respect to that. So that's sort of, broadly speaking, high-level temporary visas, permanent visas on the economic side of things. Now, if we go into the presentation, and I'll just talk a little bit more broadly. So what we're going to talk today about are judicial reviews and appeals. What are the differences between them? Some of the key considerations, timelines, and then we can have questions with respect to anything you want to talk about, basically.
Okay, all right. So before we jump into the very detailed discussion on the judicial reviews and appeals, for the audience, I would very, very quickly like to sum up something what Lev just mentioned. If you get a refusal, if you get a rejection, depending on your application type, there might be a couple of options you might have before you get into more serious matters of judicial review. First one, obviously, depending on your application type, is your request for reconsideration. As he said, it's not your statutory right in terms of that it doesn't give you an automatic reconsideration right, but depending on what your application is all about, and if you think that based on the information that is available to you, that there was genuinely an error made in the fact or law by the visa officer, then by all means prepare an application for request for reconsideration. You cannot provide any new information for your request for reconsideration, but you can highlight what you've already provided, possibly drawing the attention of the visa officer back to those materials, sort of saying that, listen, you were saying that I don't have financial assets, but I did provide you my bank statements, which shows that I have X amount of money. I provided you with documents which show that I have this much of funds, this much of assets, this much of net worth. Kindly reconsider. Keep in mind, there's a human being on the other side. Appeal to that person's better side, better nature, and maybe you might just have luck there. It's a 50-50 kind of a situation. Yeah, go ahead, sir.
I'll just add a couple of things. Generally, the more egregious the error is, the better your chances at reconsideration, in my view. So if it's a sort of a 50-50 case and you get rejected, the chances of reconsideration being successful are probably slimmer. Quite often, it will be reviewed by a senior officer or supervisor. But if the errors are egregious, which quite often happens, the officer simply missed something. You're like, I do not see proof of relationship or something like that. And you're like, actually, it's on page 5, right? You have a decent chance of getting reconsideration. Unfortunately, it will depend on, like you said, the human being on the other side and the visa office. Sometimes they'll look at it, sometimes they won't even look at it. So that's the concern. And sometimes you may involve an MP as well with a reconsideration. Sometimes you can launch it through an MP and sort of monitor it through an MP.
Sure, but I mean, again, for reconsiderations, visit visas, study visas, these are very two-way. You can very quickly, but also it's very important to understand that your refusal letter are very generic. They don't really give you the crux of what exactly went wrong in your application, and the time is of essence here in case you really want to challenge the decision. As Lev said, you have very limited time, 14-15 days if the application is inside Canada.
Yeah.
If your applicant is inside Canada, and 2 months or 60 days if you're outside Canada. This is the timeline that you have in order to appeal or raise your request for judicial review if you wish to challenge the decision in federal court. So the time is of serious, of great importance. So yes, by all means, immigration consultants cannot help you with your application appeals and judicial reviews in the federal court.
Some appeals, I think consultants can help. Some appeals, I think consultants can handle.
That's what I was saying. The immigration consultants can help you with your reconsideration request. They can certainly help you with your appeals if it is in the tribunal, which is IRB, Immigration Refugee Board. If you have a permanent residence applications for spousal sponsorship, which has been refused, which has been denied, an immigration consultant can, of course, represent you in an IRB. Of course, if the consultant himself or herself is also licensed to represent you in front of IRB. Nowadays, the license for an RCIC says RCIC or RCIC-IRB. For example, yours truly, my license would say RCIC-IRB, which basically means I am authorized to represent you as a client to IRB as well as, of course, IRCC. But if it comes to the matter of federal court, that is where the matters get very serious. And therefore, you need to have legal representation, which is an immigration lawyer, where the lawyer can then again represent your case to the judge in the federal court and obviously defend your case in the matter. This is where things get a bit more serious. This is where you need much more detailed, comprehensive counsel. These are the applications where reconsideration is not going to help. Probably, let's say reconsideration request has also been refused and you're already in the tight deadline or timeline. Mind you, GCMS notes that you would want to apply, the ATIP notes or CAPES notes, a lot of people refer to, can take time. But if you were to go to an immigration lawyer and if they are going to file an application for leave, which obviously Lev is going to go into details in a bit of time, then they can request from the court a document which will give them more disclosure as to what has happened in the application. Lev, let's delve deeper into the judicial reviews now.
I'll just add one thing to what you've said. Whether you're going to a tribunal or whether you're going to the federal court, just make sure that the person you're hiring handles the type of matter that you are seeking to challenge. Just so that they specialize, because this stuff's quite technical. So, and there's some people who really focus, for example, on stay motions or detention reviews. Others, do more spousal appeals and so on. So just make sure that the person you're hiring has experience with your particular type of application, because occasionally we see files that are basically brought to our office where the person that I hired this lawyer, I hired this consultant, and so on. And it seems like the person didn't really understand what they were doing. They were maybe learning on the person's file and so on. So just hire someone with experience in that particular type of matter.
I mean, it's the same thing, right? I mean, if you have a heart problem, you're not going to go to an orthopedic surgeon, right? You would want to go to a heart specialist, right? The same thing.
Exactly. Yeah, and good lawyers, good consultants will often say, actually, I'm not an expert in this. Here, speak to this guy or speak to that guy. He may have more experience. At the end of the day, we're in this field to help people. And if we feel like we cannot do the best job for them, there's nothing wrong with them getting some guidance somewhere else. Okay, with this in mind, judicial reviews and appeals. So we're going to talk about that. So, immigration litigation. Broadly, when we talk about immigration litigation, we're talking about individuals, typically, challenging decisions of a lower tribunal, so an immigration officer, an immigration division decision at a higher tribunal or a court. That's what we're broadly talking about. And there are two ways to do this, either a judicial review or an appeal. We'll first start talking about judicial reviews and then talk about appeals and the key differences. So, what is a judicial review? It's a legal proceeding by way of which an applicant, the party starting the proceedings, is seeking to review a decision of a tribunal. So typically it's IRCC, but it can also be ESDC or CBSA. Very important. Generally commenced at the Federal Court of Canada. When we're dealing with detention reviews, provincial courts may have inherent jurisdiction. So an important thing with respect to a judicial review, you're typically asking the court to set aside the decision. You're not asking the court to issue a decision or to replace a decision of the officer, a decision that you're challenging. And we'll talk more about the remedies a bit later. And the court will be reviewing the method by way of which the decision was reached. So the court will be looking at the key findings, how they were reached, whether the decision is procedurally fair, whether it's correct with respect to the law, whether it's within the range of sort of reasonable outcomes based on the facts before the officer. But it is a review of what happened at the initial instance and how the decision was reached. It's not a trial. You're generally not introducing new evidence. You're not going to be given testimony. And this is why it's very important. The stronger your initial application is, the better your chances. In some way, your judicial review advocacy starts with hiring the right person, preparing a strong application, because that will allow you to present better arguments at the federal court should it be rejected. So an important point. Kubeir,
before we get into the more details, I just sort of for the sake of understanding for the audience, can you just go with me through the process of how do you come to the judicial review? I mean, first would be the application for leave, and then with that understanding.
I have that process in. I have it. Okay. I have it later on. I have a whole roadmap that we can go through if you want.
Okay. All right. Sorry. Let's get on with that.
I have something reasonably comprehensive. Trust me.
Okay.
So some basic timelines. So if a matter arises in Canada, you have 15 days to commence a judicial review. If it arises outside of Canada, you have 60 days to commence a judicial review. Generally speaking, the location of the person and the decision maker will be considered. So, for example, if you filed a CEC application, you were located in Canada, it was based through express entry, you're likely looking at 15 days. An FSW submitted through express entry outland typically is 60 days. An extension in Canada is typically 15 days. A work permit from outside of Canada is 60 days. So those are just some basic examples of the timelines. Why are the timelines important? As Kubeir mentioned, GCMS notes, if they ever arrive, may take more than 60 days. They will certainly take more than 15 days. And if you do not file your application for leave in judicial review within the prescribed timeframes, you may lose that procedural right. So what we occasionally do is when a client is unsure, we'll commence the proceeding, we'll get the reasons, we'll review them with the client, and then we'll provide guidance saying, hey, look, the reasons are actually quite detailed and they're well argued, and I think it makes sense for you to file a new application. Or, you know what, the reasons are quite problematic. So what I recommend we do is we proceed with the judicial review, but we also file a reconsideration request so that maybe we overturn this without actually getting to court, getting to a hearing, and so on. If the reconsideration reconsideration request is denied, sometimes we can seek a judicial review with respect to that, consolidate, so join them in one proceeding, and then the court will look at both. So that's with respect to timelines. So sometimes people come to us. We recently had a fantastic case, Indian student. First rejection more than a year ago based on the officer saying your institution is not a genuine institution. Basically says his high school is fake. The student is shocked, goes to the local authorities, obtains some certificates from, this is in Goa province, obtains certificates from the Ministry of Education and so on, files a reconsideration request with the MP. The family is shocked. After about 4 months, and this is, the reconsideration request took another, whatever this 6 months goes, and he's shocked. The reconsideration request is denied. So basically, they've looked at it again and so on. Hires us, we tell them, well, you're late by about a year on the GR, and you're late by about whatever it is. Actually, I don't think he was late on the reconsideration. He was just late on the original thing. We filed 2 separate judicial reviews. We then consolidate them. I reach out to the Department of Justice. I've been doing this for a while. Luckily, I got a fantastic lawyer. I say, look, this is actually pretty outrageous. And here are the documents that he submitted, because the high school is genuine. And fortunately, we were able to overturn it. But in our application, without a hearing, but in our application for leave, we asked for an extension of time to commence proceedings. So even if you're late with the 15 or 60 days, you may still seek an extension. And the test on that extension is something that I've put on the screen, Kubeir, if you can just pop it. So basically, if you're late by a few days, but if you maintain the desire to proceed with the judicial review and there's a reasonable explanation for the delay, maybe you didn't fully understand the proceeding and were just relying on reconsideration, or there's some other factors such as some health concern or stuff like that, you may still be able to commence proceedings subject to the court allowing you to do so. So don't think that just because you're late by a day, you're necessarily barred from seeking a remedy. Okay, so that's on the extension. Here's the roadmap.
Just on that back, so the timeline that you have here, does that start from the day you get the decision, or from the day you get the decision or the reconsideration?
It starts from the date you get the decision. So a reconsideration decision is a different decision. They're separate decisions. So you'll have two decisions potentially. The initial refusal, you get the refusal letter. You commence your judicial review. The judicial review will lead to the court ordering the tribunal to produce the reasons. You get your reasons, which are produced pursuant to Rule 9, which is why we refer to them as Rule 9 reasons. You review your reasons with the lawyer or consultant or whoever. You then determine whether you want to proceed or not with your judicial review or whatever it is you want to do. So an important note, as your audience probably knows, typically when you get a rejection, you'll just get some boilerplate language and you won't get the actual reasons. And until you get the reasons, and the reasons you can think about them as an X-ray or an MRI or something like that. You come to the doctor and say, hey, I have a problem. Doctor's going to say, hey, let's do some tests. Tests are going to produce the results. What are those results? They're akin to reasons. And the reasons are put into the GCMS system. They're typically quite terse, but they should provide enough substance for you to understand. Okay, so that's sort of broadly. So let's just look at the timeline, and this may look a lot more complex than it is. It really isn't. Basically, you get a decision rejecting your visa application. You then hire a lawyer to commence an application for leave and judicial review. Why do we say leave and judicial review? Because to have your case reviewed by the court is not an automatic right. You first have to get the court to agree or to grant leave to review the matter. So leave and judicial review. You commence an application for leave and judicial review at the federal court. You get your reasons. From the time you get your reasons, you get 30 days to perfect your application. What does perfection mean? Perfection means establishing a proper legal proceeding before the court, thereby putting the evidentiary record as well as the submissions so that the court can understand your case and make a decision. So you file your application record, you perfect within 30 days of getting your reasons. So those timelines are important. So if you've hired someone that have not done anything within 30 days, you may have issues and you may need to seek an extension and so on, because it's very important to comply with the timelines. The Department of Justice, acting for the Minister of Citizenship and Immigration, if we're talking about an IRCC case, then has 30 days to respond to your submissions. Quite often, if you have a decent case, if it makes sense, what your lawyer will do, we will certainly do this in cases where it makes sense, we'll reach out to the Department of Justice and say, hey, the errors here are plain and obvious. This is putting our client in a bad position. This is quite unreasonable, etc., etc. Let's settle the case. The Department of Justice lawyer will then reach out to the minister's representative who has broad powers, who is generally has sort of broader jurisdiction than an immigration officer, and will then discuss a possible settlement. And the settlement will typically involve the matter going back, sometimes going back with instructions, i.e. the officer will do this, the officer will consider this and that. Kubeir, I see you want to ask me a question. Feel free.
No, I mean, all I was just trying to sort of, get to that is that, I mean, I would want to wait till you finish to say that there is a good possibility that your application may be considered even at the lead stage, just as you were explaining.
Not so much at the lead stage. Typically, with the judicial review, the DOJ, sometimes we settle cases at the lead stage. At the I guess you meant at the leave stage. Yeah, prior to leave being granted. Yes, correct. Quite often, after you file your record, you have a better chance of settlement because the Department of Justice can then understand your arguments, discuss them with the minister's rep, and so on. and many decent, many reasonably strong cases are settled without a hearing. I have to say that on the whole, I give the Department of Justice lawyers a lot of credit in terms of how they've conducted themselves, both legally and just as human beings, throughout this period of delays, backlogs, unreasonable refusals, etc. I generally think that they do a very good job in settling cases that should be settled, in pushing for settlement. Not all of them, of course, but most of them. And I think they have maybe done better than IRCC has done throughout this period in trying to resolve matters. Yeah. Okay, so going back to our little roadmap here. After the Department of Justice files their responding materials, so the respondent's memorandum of argument and possibly an affidavit from a clerk or an officer, the matter will then go for the leave stage. And the leave stage in this lovely chart here is here where my mouse is. So it's between steps 7 and 8. And the court will basically decide whether there is an arguable case here that should be heard. Typically, if the court issues a production order, an order directing the tribunal to issue the complete record for the proceedings, you will get leave. Once leave is granted, you will have a timeline with respect to other procedural steps and then a hearing. Now, the parties may decide to settle the case without a hearing, happens occasionally, but in my experience, most cases settle, generally speaking, settle after the applicant's record is filed. If the court agrees with you in the decision being either based on the breach of procedural fairness or containing an error, it will be set aside, and the matter will then be sent back to a different visa officer, or sometimes even a different visa office. If the court assesses the evidence or provides some guidance with respect to the underlying issues in the case, the next visa officer will be bound by the court's analysis. It's very important to know that. So even if you're not getting specific instructions or directions from the court, if a judge considers the case and says, I actually find the humanitarian compassion factors in this case are quite strong, contrary to what the officer said, or I find that the officer's assessment of the financials is patently unreasonable because he ignores the fact that the uncle has in fact supported the applicant before, whatever else, the next officer is bound by that. So very important. Sometimes people say, well, why should I submit an application for judicial review only for it to go back to a different officer and be rejected and so on? Sometimes it's hard to get an approval without the judicial review. A lot of information here. We'll talk more about this in the next slide. And we'll talk more about some of the specifics. But Kubeir, feel free to step in. If there's a question that you think I need to address at this stage,
No, I don't have any specific question, but I was just thinking that for the general audience, it's quite technical in a lot of ways as to what the process, how it goes. I mean, if I'm a lawyer, if I'm a consultant, this is extremely helpful for me to understand. But for the general audience, I think their main concern is only to do with what will happen to my application. So let's talk about that very, very broadly. Because to be very honest, they are not really concerned what exactly happens once the application goes for leave, for hearing, how will that be handled. I guess their main concern would be, when should I go for a judicial review? When should I not go for a judicial review? How much does it charge? How much does it cost? How much time does the whole process take? What would be my obligation? What would be requirements from me? What would I need to do?
Sure. So generally speaking, briefly, a judicial review is a process by way of which you're asking the court to set aside a decision of a visa officer. That's broadly.
Yes.
Good cases can be settled on consent, meaning by way of an agreement without a court hearing with the Department of Justice, acting for the minister, typically within 40 to maybe 70 days from the time you start your proceedings. So think about that. If you have a decent case, you commence the application for leave, you perfect it, you reach out to the DOJ, and quite possible that within, let's say, 50 to 70 days, your matter has already gone back. When your matter is going back, the visa office, the visa officer, etc., understands a mistake was made. Okay, Typically, what we'll do is we'll also provide submissions as to why the matter went back, what the issues were, and how it should be looked at. Generally speaking, while a successful judicial review, either when a matter goes back on consent or through a judge's order, is exponentially increasing the chances of approval. But it does not guarantee approval. I've had tough applications where I had to run the thing a few times from the federal court. At the end of the day, I got approvals. In some cases, I got directions from, basically an order saying, the matter will be considered in such a way. But that's briefly, you're seeking to challenge a decision. You're looking at hopefully settling the matter on consent. The matter doesn't settle on consent within the time frame that I said, let's say 50 to 70 days. You'll have to wait for the court to decide whether to hear it. If the court will hear it, this typically takes 4 to 6 months from the time you start proceedings. You'll have a hearing. You do not have to attend that hearing. Very important. Also, generally speaking, no new evidence. So whatever was before the decision maker will be before the court. And then a judge will decide whether the decision should be set aside or not. We'll talk about some additional relief you may seek. That's very, very big picture.
Okay. Got that.
I'll just briefly talk about timelines.
Also tell me about timing and the costs as well. Sorry.
Okay, so briefly, if you can just open the presentation again.
Yeah.
There.
There you go.
Okay. So briefly, timelines, generally speaking, 4 to 6 months to get leave, 10 to 12 months to get a hearing. And in the next one, I provide a sample timeline if you want, if it helps. So this particular case took 5 months to get leave and 10 months to get a hearing. Now, there's going to be no hearing here because this was a mandamus matter and the decision was issued, but the procedure on the general denial is the same. Okay, costs. How much does this wonderful process cost? So costs can vary depending on the complexity of the matter and depending on who you hire. Generally speaking, for the first stage, you're looking with our firm, between about $4,500 to maybe $6,500 to $7,000 for the stage up to perfection and settlement discussions. Generally speaking, some lawyers will charge more, some lawyers will charge less. It will also depend on the complexity. For example, right now, I'm doing a judicial review based on the breach of procedural fairness. Nova Scotia PNP based work permit and PR application for express entry. The officer calls the employer, says, "Hey, does so-and-so work here?" He says, "No, never heard of him." My client gets a PFL. I'm not representing him on the application. PFL just says, "We have concerns with respect to your employment letter." Client submits another letter, some other information from the employer. Application is rejected because actually the officer called, the officer had some other concerns. So a breach of procedural fairness because the client didn't understand what happened. The reason that the guy who picked up the phone was young, was there by virtue of having a connection to the family that owns the business and was going through some mental health issues. And our client didn't appreciate what happened. Also, the business had, I think, 30 to 40 employees that were constantly being rotated. Most of them were paid in cash, etc. Basically, a judicial review like this involves us trying to introduce some degree of new evidence to provide procedural background. It's complicated and so on. It will cost more. Let's say more routine student visa denial will cost less. But roughly, I've given you an idea about $4,500 to maybe $6,500 for stage one. If you're going for a hearing, can cost you between, let's say, $2,500 to maybe $4,000 again, depending on the lawyer. So the overall cost you're looking at is maybe between, let's say, $7,000 and $10,000 roughly, not all payable at the same time. So if you just want to start an application for leave judicial review, you're not yet sure if you want to proceed, you want to get the reasons, lawyers will charge different amounts for the preparation of the application for leave and subsequent discussions with you. You may be looking at between $2,000 or $1,500 and $2,500 and so on. Rough, every lawyer or different lawyers will have different prices.
Of course. So you're saying stage one would be until the application for leave?
Yeah, stage one will be an application for leave. Now, if you want your lawyer, or if it makes sense to cross-examine the officer, there may be an extra charge. If it makes sense to file a supplemental affidavit from you, there may be an extra charge. If it makes sense for you to or for us to prepare a further memorandum of argument, there may be an extra charge, and so on. Generally speaking, I have to say that most lawyers are mindful of the fact that this stuff's expensive and are trying to do it in the best way possible, balancing our procedural obligations and our trying to do the best thing we can do, but also understanding some financial constraints and concerns. Generally speaking, when you talk to civil litigation lawyers in Toronto, many are charging between $500 and $700 an hour. Nobody does stuff on a flat fee basis and so on. Immigration litigation is quite different. Most of it is flat fee.
Okay. All right. Got it. So stage one, let's say until the application for leave, you are looking at about $4,500 on an average, again, give or take, depending on the complexity. And if it gets to the hearing stage, there could be an additional fee of up to $3,000 to $4,000, again, depending on the complexity.
It depends on how complex this is, what type of matter we're dealing with, etc. Like if you were bringing a charter challenge with respect to some provision of the act, it may be more complex. Or a lawyer may take it for free, saying, you know what? Some lawyers will try to get class proceedings going, right? So let's say similarly placed applicants are rejected in a procedurally unfair way. They may bring them together. You can even file, for example, potentially a class mandamus proceeding. Let's say you're this wonderful self-employed category that we have for the best people in the world, artists and athletes. What's it, 50 months? Yeah. So you may get a few applicants together and commence proceedings and so on. Just speak to a lawyer about this. Don't just go based on what I'm saying here in this presentation.
No, I get that. So just to sort of give everybody a very general understanding of what it will cost you to start the process, anywhere in the range of $4,500 to $4,500, and the whole process until the hearing or the whole GR, if it gets to that stage, you're looking at roughly $7,000 to $10,000 is what you are looking to spend at least. Depending on complexity or the nature of the application.
Right.
All right.
And depending on who you hire and so on. Yeah. So let's go back to the presentation. Okay, so this is a quick timeline. ALGR means we commence proceedings on June 24th. Production order, October 25th. Leave. So a court says, we're going to hear your case. December 2nd. Hearing schedule for March 2nd. This case is not proceeding. A decision's been issued, but that's a rough timeline. Okay, so appeals. So first of all, and I mostly practice on the judicial review side of things. I've done appeals as well, and I do appeals, but most of my practice is on judicial reviews. So who gets an appeal versus a judicial review? So appeals generally go to specialized tribunals, such as the Immigration Appeal Division or the Refugee Appeal Division. I'll mostly speak about the IAD here, because I think most of your audience is probably interested in that appeal process. The general principle is, unless a statute gives you the right to an appeal, you're generally looking at the judicial review. How are appeals and judicial reviews different? On appeal, the IAD has the right to consider new evidence and in some cases humanitarian compassion factors. In fact, in some cases, your appeal or the relief you're seeking may be based on humanitarian compassionate factors. So who gets appeals, generally speaking? Appeals are generally better than judicial reviews. So who gets them? Permanent residents will generally get an appeal. If you're sponsoring your spouse and it's outland, you'll generally get an appeal. If you're looking at a deportation order and you're a permanent resident, you'll have an appeal, etc. So permanent residents, those who are already in Canada, have generally greater rights. So if you want to sort of think about it broadly, you should consult a lawyer or a consultant who practices in this area to understand what your rights are. And I'll have a chart, Kubeir, with respect to sort of showing where things go, appeal versus judicial review, just to make it visual.
Okay.
So the key thing, new evidence is allowed. You'll have a hearing if the appeal proceeds. You'll give viva voce or live evidence. The minister rep will cross-examine you, which is completely different to a judicial review where you don't have to be present at the hearing. There's generally no new evidence and so on. Okay, so let's go to the next slide here. So the other key thing, the Immigration Appeal Division has the right to issue its own decision. So it can actually approve something or stay something or give you the relief that you're seeking, as opposed to the federal court, which is generally just going to quash the decision and send the matter back. So very important. Now, if you're unhappy with the ID's decision, you may then seek a judicial review with respect to that decision, not the original decision.
Yeah.
Okay. So here's a very basic chart, and there's some exceptions to this. So economic-based permanent residency application, judicial review. Temporary residence, judicial review. Inland spousal sponsorship, bizarrely a judicial review. Hopefully, should change soon. Citizenship, judicial review. If you're seeking a mandamus, it's a judicial review. A stay motion with respect to somebody who's not a permanent resident, you're typically looking at judicial review. Or if someone has a conviction that is longer than 6 months and some other charges or some other conditions, we can talk about that. Appeals, outland spousal sponsorship, parental sponsorship, PR card renewal, removal order. So very briefly, I think most of your audience, I'd imagine, is more interested in judicial reviews. So a few exemptions to the general principle: no access to the ID in the following cases: inland spousal sponsorship, as I said, inadmissible to count of security, human rights, organized crime, sponsored found ineligible. So in that case, there's no actual decision to appeal, it's just eligibility. Criminal conviction, so more than 6 months sentence or prison terms, or convicted of a crime outside Canada will be punished by more than 10 years. So in certain cases, you would normally have a right to an ID appeal, but you will not because certain conditions are met. I frankly don't think that some of this are reasonable. Like for an inland spousal sponsorship, it doesn't make sense not to have an appeal to the ID, and basically some of those are sort of, I think, are factors where I think it was the Harper government in some cases they were trying to limit access to the ID division unreasonably. You want to say something?
Yeah. No, I mean, I agree with you. I mean, sometimes I don't understand why should inside Canada sponsorship not have an access to appeal when outside Canada?
I think they look at it as a change of conditions as opposed to a decision. I think it's technical and a bit silly. Well, I won't dwell on this. Again, some of the stuff is technical. Don't rely on what I'm saying in this presentation. If you have a question, contact a lawyer or consultant. Okay, appeal timelines, generally speaking. So you have 30 days from the day you are aware of the decision to commence your appeal. You fill out a form. You file that form with the appeal division. The minister will then produce an appeal record, which is akin to a certified tribunal record in many ways. So it will have your applications and the decision. Quite often, you'll have the right to an informer or alternative dispute resolution conference. Very important, because and this is a major difference, another major difference between a judicial review and an appeal. In the judicial review, settlement discussions are pretty much discretionary. I can call the DOJ and can say, you know what, Lev, I'm going on vacation. I don't feel like talking to you, and my client is busy, and so on. Here, quite often, you can either have an alternative dispute resolution scheduled as of right, or you can request one. You can say this case perfectly fits the ADR model, and during the alternative dispute resolution, you, the minister's rep, and the representative of the ID will discuss the case and possibly settle it. And I remember settling one other relative appeal after my client, was asked a few questions. With the ID dispute resolution officer, and it was a wonderful sort of way to deal with things as opposed to having a matter be litigated further and so on. So if the matter is not settled, you'll have a hearing. It can take from a year to 2 to have your hearing. Prior to the hearing, you'll file the evidence you wish to rely on. You'll file witness will say statements, and then at the hearing, you'll be given evidence in chief. You'll be cross-examined on that evidence. Your witnesses will give evidence. Your witnesses will be cross-examined. Your counsel will then provide submissions to the ID, and minister's rep will provide submissions. And then at the end of it all, a decision will be made. Very important. Sometimes the minister's rep wants to see what evidence is before he's in a position to settle. So I recently had DUI-based criminal admissibility. My client had a number of DUIs. He had some problems with alcohol. He was he filed an appeal against the deportation order based on humanitarian compassionate grounds. And after he was cross-examined, me and the minister's rep agreed to settle the case. So not all cases necessarily need a decision from the decision maker. Again, many officers have a pragmatic approach. They want to understand the evidence, and then they're in a position to possibly reach a settlement. Okay, so that's appeal generals, major difference. New evidence is allowed. H&C considerations can be pled. An ADR dispute, generally a more involved trial-like process. Okay, H&C factors with respect to a stay of removal. So I don't know if you want to go into them, but basically in certain cases, the tribunal will have the right to consider H&C relief. So how serious was your offense? This is if you were seeking a stay of removal. The likelihood of you reoffending. How long were you in Canada? You know, if you're very well established in your offenses, you know, it's your first DUI and so on, and you've showed efforts to rehabilitate. You've taken actions, courses, Alcoholics Anonymous, whatever. So some of those factors can be considered. They're not exhaustive, and you can actually get relief based on H&C factors. If you're dealing with a PR renewal obligations, a very typical appeal, somebody doesn't comply with the permanent residency requirement, submits an application, it's denied, they appeal to the ID, you know, the ID will again look at H&C factors here, non-exhaustive, which is great, right? Because the federal court is not going to say, well, I find the officer, you know, erred, but I have jurisdiction to look at H&C factors. So an appeal is generally better than a judicial review, just by sort of the powers of the decision maker. So some general questions. Whether you have an appeal or judicial review is a matter of statute. The stronger your initial application to a visa post, the better chances of you being successful in a GR. You have 15 or 60 days, and 80 notes often take longer, so it quite often makes sense to commence proceedings, preserve your rights, and then ultimately determine how you want to proceed. Generally speaking, with a few exceptions, you're not introducing new evidence on the judicial review. We are introducing some additional general information on this judicial review we're doing for the work permit denial because there was a breach of procedural fairness. GR generally opens the door for you to speak to DOJ counsel, who will then get instructions from the minister's representative. We recently had the rejection of a parental sponsorship based on Section 34 inadmissibility. It's hard to challenge the rejection, but in the alternative, we ask for TRPs. TRPs are never considered. I file a GR for the rejection of the parental sponsorship as well as the TRPs. I write to ministers to the Department of Justice. And voila, within 2 weeks, the Law and None Office is sending us additional requests. Otherwise, my client would be waiting for a year for this TRP, which was ignored to begin with. So a GR sometimes, does more than just allow you to argue sort of legal or present legal arguments. Successful GR does not guarantee an approval, but generally will greatly increase your chances. In some cases, you may negotiate a settlement with directions to the next visa officer, which obviously tells them how to approach a case. So, for example, I've done a couple where we've agreed that the humanitarian compassionate considerations were strong. You can have a particular type of an assessment, etc. In general, you can plead this, so you can ask for this. The judge will say, well, you don't meet the exceptional test. But at the same time, if the judge assesses them without giving directions explicitly, the officer is bound by them. That's the beauty of sort of playing this litigation game. So some recent litigation, we recently overturned an H&C rejection. Decision was heavily criticized. It's a challenging H&C application. We've resubmitted it. We'll see what happens. I told you about the student visa denial with a 5-year ban. There's lots of, by the way, unreasonable bans in my mind when it comes to Indian nationals. I think that there are a lot of consultants there in India who are not licensed and who are producing all kind of fraudulent documents and are not actually being held responsible. Sometimes there are also cases of innocent mistakes or just the misapprehension of evidence leading to denials. So, which is unfortunate because there's serious consequences. And case law says If you're facing a 5-year inadmissibility ban, then the procedural fairness should be higher than on a general student visa.
It should, yes.
Work permit refusal overturned on consent, approval issued. I talked to you about the IED. Parental sponsorship TRP, that's a recent file. So I'm hoping they're going to get TRPs instead of PR. So TRPs with multiple, so temporary resident permits, which are ministers' sort of relief to allow them to enter Canada. Recently had a super visa approved after 2 rejections on the JR. Yeah, basically it. And there's a wide range of things that you can do on the JR. Okay, I'll leave it open, I guess, to questions. I know we covered a lot of information here.
All right. So, I mean, I don't see any questions basically very specific to what we have been discussing about. But very quickly, when considering a JR can be an expensive process, it's not everybody's cup of tea, not everybody can afford it. When should a person start looking at a process of a judicial review or challenging a decision versus making a new application? Because making a new application is just a new application fee. That's it, right? But when should a person be looking to do this versus that?
Well, first of all, if you've had a number of the rejections. So, for example, right now we're doing, we just submitted a visitor visa application for a Belarusian national. This lady previously got 4 refusals. She did a couple of applications on her own, a couple with a lawyer, I think. The chances is that she's going to be refused again because the previous officer, the new officer is going to look at all the concerns on record, et cetera, et cetera. So we're preparing it basically for the federal court. We've put in the work to tell the client, look, you're going to end up in federal court. We'll have to clear the slate, if you will, and then you're likely going to get an approval. So if you have multiple refusals, consider a GR. If your initial application was prepared to a tip-top standard, everything was done, and you still got denied, consider a GR, especially if you filed the reconsideration request. If your application is problematic, so for example, I had files, permanent residency applications, there were protected people trying to get their spouse over, and there were H&C factors pled. They were complicated. I told them, look, unfortunately, we're going to have to go through the federal court. I was dealing with the Kyiv office, and they were just not going to approve this particular application. Like, it was clear from the supervisor on. After 2 GRs, it went to the London office. We got an approval, right? So those are some general considerations. If you received a very unreasonable decision, you filed the reconsideration request that was denied, you have the means, you may be able to quickly settle the case with the DOJ, and the minister's rep may have some correspondence with the visa office, even though they always say, oh, the officer has the jurisdiction, cannot fetter discretion. We've seen them, change their mind pretty radically after sort of getting something from the rep and so on. So those are general considerations.
Okay. All right.
Well, here's a question. I'll just say one thing. With appeals, you have to keep in mind, in some cases, if you do not appeal something, like with a GR, you say, okay, well, I'm not going to GR, I'm just going to reapply, or I'm going to just not come to Canada. With an appeal, something's been denied and you don't appeal it, you're going to be deported, or you may not be able to file a new application. Just something to reconsider, a different procedure.
Okay. Got it. Right. So here's a question. My 7-year-old daughter was given an eviction notice. What she means is probably a removal order to leave Canada as soon as possible because of the expiration of 90-day restoration. Is there anything I can do?
Well, first of all, I'd like not to be providing guidance.
Any advice? Yes.
Because I don't want to get sued. I'll just say generally to this person, you can certainly challenge the denial of a restoration request, but the problem is that in the meantime, your daughter is here without status. So it depends on where you're from. You may leave Canada and then re-enter. You may ask for a temporary resident permit. It really depends on your circumstances. I don't know if you want to chime in here, Kubeir.
Obviously, guys, none of this is going to be a legal advice, because that's the disclaimer here. It can only be a general information so that you can then take pointers from it and choose to then consult a lawyer, consultant, depending on your case. Yeah, in this case, even I would have thought maybe TRP would be an option that somebody in this condition could consider. Of course, if that person is from a visa exempt country, then they can leave Canada, return back with an ETA. That also makes a good sense. The fact that you had your 90-day restoration application refused, that itself, no, actually, it's not an application. It's just that the person apparently didn't apply for restoration at
I
all.
guess they didn't apply, yeah.
Yeah, just didn't apply. Well, yeah, sure. So probably TRP is an option, or leaving Canada and returning back would be another one, which would be probably better. Right. I don't see any other questions as such specifically related to the subject that we are discussing about today. There is one which spoke about refusal. Yeah. So just to this person, I've got a rejection of an Australian visit visa. Should I mention it while filing my study visa? You should always, always, always disclose all information truthfully, honestly on your application. That includes mentioning all your previous refusals. Not mentioning your previous refusals could simply not only get you a refusal of your current immigration application, it could also lead to a 5-year ban for misrepresentation because you have not disclosed the information that you are expected to or obliged to.
I'll just maybe add to that maybe briefly, and perhaps explain the nature of the refusal. If you understand why you were refused, if etc., just to maybe make the officer's analysis a little easier. Yeah, but you should disclose that.
Okay. Right. Thank you so much, Lev. I really, really appreciate your taking a Sunday morning off just to sort of share this incredible information and obviously the updates in terms of whatever is happening with the TRVs earlier. I thank you so much. And guys, if you are at all looking for an immigration lawyer to consult with, to understand what your options are for your JRs, for your appeals, even for mandamus, because mandamus still is quite an option.
It still is a very active thing. Despite this proposed amnesty, we're still seeing a lot of applications. It will take a lot of time to play out. And certain visa officers or citizenship applications are still stuck that we're seeing. So yeah, it's still an option. And I'd just like to tell your audience, sometimes it's very disappointing to get a rejection and you may feel like, oh, it's the end of the road. Canada doesn't want me. But officers are dealing with millions of applications. Quite often they make mistakes. Quite often they rely on artificial intelligence tools in a reasonable way. So understand your rights and fight for your rights. Don't give up just because you got a rejection. Our firm and other firms have helped clients come to Canada even though they received the initial rejection. So understand your rights and don't be afraid to ask for or to file a judicial review or an appeal if you think there was a mistake.
Right. Thank you so much once again, Lev. It was great having you. We will definitely do this or something similar again.
Thank you so much, Kubeir. Thank you.
Have a great day ahead, man. Thank you. Right. So that was Lev. Thanking him so much, right? So, I mean, not a lot of people would like to come out and discuss this and give you these incredible jewels of wisdom and information to understand what you can, what you cannot do with your application. But again, to summarize what you can do with a refused application, rejected application, first of all, obviously go through your application. The first step should be prepare a good application. Like, for example, in our company, in our firm, we start the backwards process. We obviously always consider all applications will be refused. That's what we consider. And therefore, we back up and prepare an application so that if an application actually does get refused, what can we do in terms of the remedy? What can we do in terms of challenging that? So when you've prepared the application in a manner, you're already covering up as to what you will be able to do with that application. You usually then have a good application, something like reverse engineering the whole process. So obviously prepare a good application. If you've already done that, and if you have identified in your refusal or rejection that there was indeed an error or a judgment error or error in fact or law made by the visa officer, then request for reconsideration. When you're requesting for reconsideration, you cannot provide anything new in terms of evidence or supporting document. What you can provide is highlighting the instances that were already included in your application, draw the attention of the visa officer, telling them that please consider this. I've already given you this information. Of course, apply for GCMS notes, ATIP notes to understand the exact reason why your application was refused or what the officer's concerns were. And if you understand those concerns and if addressing those concerns is within your reach, for example, providing new documents, additional documents, better explanations, SOPs, redrafting an SOP, providing a better study plan, providing more funds, providing more ties to home country. If you can do any of this or all of this, then consider doing a new application because, of course, that's cheaper. But if you're in a situation where you think you've done everything possible, yet you've got a refusal, yet you've got a rejection, which you think was unfair, unjust, then please do consult with an immigration lawyer and look and seek your options for a judicial review, because in a lot of cases, coming to Canada or making that application was your only choice or your only option. You cannot make any more applications. Can happen with a lot of PR applications as well. That was your only ITA, only chance you got a shot at. And in that case, if it's not going to work out, then a JR, a judicial review, is something which you can work at, which you can look at. Also keep in mind, a judicial review does not mean an automatic approval. Just because a judge has ruled in your favor does not mean that you will get an automatic approval. It basically means it will be sent back for to another officer for their consideration or their reassessment, and then they may ask you for new documents. Of course, in most cases it will turn out to be approval, but it's not a guaranteed one. These are the ways, these are the steps, these are the processes that you can look at and move on from there. Let's hope that you don't get a refusal at all. Obviously, the first step for that would be to prepare a good application. But if you do, then now you know what your options are. Now you know what you can do. And hopefully you would be able to avoid these options and remedies. Instead, have a good application itself. Because just the way we are forever hopeful, and we look to making sure that we have a good application to start with. Thank you so much for joining in. It was a Sunday morning, and the sun is still up, and we've got to do a lot of things what we do with a Sunday. Stay safe, take care, and stay forever hopeful.